Hi, welcome back to my channel. Please like, comment, and subscribe. The maritime industry is a critical part of Alabama's economy. Maritime workers support a wide range of oil and gas, international trade, and tourism companies that operate along the Gulf Coast. When people get hurt doing these jobs on or near the water, state and federal law determine how to administer benefits and address any legal claims. These injuries can be quite serious, but most do not fall under normal workers' compensation requirements. Instead, they are subject to federally mandated programs that are specific to the maritime industry. If you or a loved one have been injured on a ship, boat, dock, or oil rig, you may have questions about your right to benefits under these programs. At Turner, Underdog, Kimbrough, and Howell, PA, we have been protecting the interests of clients throughout Alabama for over 75 years. Contact our office today to schedule a free consultation. Common maritime accidents and injuries working on or near the water can be incredibly dangerous. Boats and docks are full of hazards that you are not going to find in a regular work environment. Some of the most common maritime accidents and injuries include falling overboard. Falling into the water is a common accident and it can also be one with fatal consequences. Maritime workers can be swept off of dock or boats due to inclement weather or moving equipment. If they do not drown or die from hypothermia before being rescued, other injuries are possible. Bone and joint injuries. Maritime work is some of the most physically demanding work available. It is not uncommon for a worker to sustain serious injuries from falling equipment, dangerous machinery, or overexertion. Chemical exposure. There are a lot of chemicals on docks and boats that can cause harm from exposure, and some are even highly flammable. A worker could be injured if they inhale a chemical, get burned in a chemical fire, or have one get absorbed in their skin. How maritime laws protect injured workers? Several maritime acts protect workers that hurt or killed on or near navigable waters, but the two most common are the Jones Act and the Longshore and Harbor Workers' Compensation Act, or LHWCA. These are both federally mandated programs. The main distinction between the two is that the Jones Act covers workers who are seamen, and the LHWCA covers other categories of workers that may also be in the maritime industry. Getting help for maritime injuries through the Jones Act. Seamen covered under the Jones Act can sue their employer for work-related injuries caused by negligence. To win, the employee must show that the negligence caused or contributed to the accidents and their resulting injuries. For example, an employer that failed to fix a known hazard on a vessel would be responsible when the hazard caused a serious injury. That is just one example of negligence that could justify a Jones Act claim. Some others include inadequate training for seamen, defective or faulty equipment, inadequate or missing safety equipment, demanding too many hours on the job, navigational errors, inappropriate or unsafe protocols, assault by or negligence on the part of another crew member, emphasizing speed over safety, failure to evacuate crew or provide timely medical attention. Who is covered by the Jones Act? The Jones Act offers protection for individuals working on vessels or ships. Some examples of the types of vessels covered include cargo ships, tankers, tugboats, construction barge, fishing vessels, floating cranes, trailing rig, cruise ships. The Jones Act covers seamen, but that doesn't necessarily mean you need to traveling the high seas. Some examples of employees that may be covered include masters, maids, deckhands, stewards, cooks, engineers, pilots, surveyors, oil rig workers. The law has a 30% standard which states that the employee must work on a vessel at least 30% of the time. Benefits available under the Jones Act. If you or a loved one has been injured as a seaman through the negligence of another party, you have the right to pursue compensation. Some of the damages you can claim include present and future medical costs, lost wages, loss of lifetime earning capacity, living expenses during recovery, physical and mental anguish. Unfortunately, few insurance companies will pay the full value of your compensation without a fight. Contact our office today and we will be your strongest legal advocate. Longshore and Harbor Workers' Compensation Act or LHWCA. The Longshore and Harbor Workers' Compensation Act work similar to the Jones Act. The difference is that this law provides benefits to maritime workers who repair ships, load and unload cargo, work on piers and decks, and etc. It excludes workers covered by the Jones Act or by state workers' compensation programs. What to do if you have suffered a maritime injury? What you do just after a maritime injury could have a big impact on your case. If you have been injured, here are a few steps you can take to protect your rights. Report your injury to your employer promptly. Get immediate medical attention even if you feel you do not need it. Document the accident with notes, photos, and witness names. Speak with a qualified maritime injury attorney as soon as possible. Even if your employer and their insurance company are open to paying benefits, there is no guarantee that you are being treated fairly. Before you sign anything or speak with a claims adjuster, discuss your case with an injury attorney that can thoroughly review your situation. Contact an experienced Alabama maritime injury attorney. If you or a loved one have been hurt, it is vital that you understand your legal rights. Even if you are being paid benefits, you may not be getting the full amount you need and deserve. At Turner, Underdog, Kimbrough, and Howell, PA, we offer free case reviews to help you understand your options. Thank you so much for watching. Don't forget to like, comment, and also subscribe.